Court, in a very important constitution bench judgment, has today said that irretrievable breakdown of marriage can be considered a grounds for divorce, and the divorce can be granted by the Supreme Court in using its powers under Article 142 of the Constitution of India to give complete justice. We're speaking to Senior Advocate Indira Jaising on this matter. Ma'am, what does this really mean? Because the court has put in some riders, some conditions. What does this mean now for couples who've been waiting to get divorced or get separated for a long time? Can anybody use this forum, so to speak, or what are the conditions exactly?
So you hit the nail on the head when you use the word quote unquote waiting for a long time. I think what was of great concern to the court is that there is something known as a limping marriage, where people are married and not married. Okay, so this is meant to deal with that kind of situation. Don't forget the importance of the words quote unquote irretrievable breakdown of marriage. So the emphasis is on the word irretrievable. It will still require a court of law to come to the conclusion that no matter what you do, you cannot put this marriage together. And in those circumstances, my own experience tells me that very often in circumstances like that, one of the two people to the marriage is still opposing the divorce. Okay. It could be for any reason. One doesn't know. It can be for emotional reasons. It can be for financial reasons. It can be for any reason whatsoever. But in a situation like that, where it is so obvious to the court and to everybody concerned that there is no marriage left in fact or in law, this judgment can be of some help.
Just to clarify that for our viewers, ma'am, how exactly has the court defined irretrievable breakdown? Because normally that is where there has been a separation for more than 5 years or even longer, or there are multiple cases against each other, or there is a mutual consent to grant that to separate, but the legal process is taking time. What exactly are the criteria in this situation?
Yeah. So, see, you mentioned a few of them yourself. Let's say that two people have already filed a petition for mutual consent and then one of them withdraws. It's again a common situation. But the very fact that two people have mutually agreed to divorce, it does show you that there is that irretrievable element is there. It's broken down because one of them is saying, I still want the mutual consent. The other is saying no. So that's one example. But the court has given like a period of a minimum of 6 years, so to say, of let's say separation. Let's say no cohabitation whatsoever for 6 years. There is a presumption that the marriage is broken down. But I'll tell you, in actual practice, I have been dealing with cases where petitions have been pending in court for over 20 years. Okay. And one person is saying, I need the divorce, I want the divorce for XYZ reason, any reason, and the other person is opposing it. Now, that's a classical case of a limping marriage. And I have no doubt in a case like that, perhaps the Supreme Court will say, it doesn't matter who was at fault. You have to basically understand that this is a movement away from the fault theory of divorce to a theory of divorce which says it doesn't matter who's at fault. What matters is there a marriage to call a marriage at all? And if there isn't, it's best to separate.
Does that mean that if there is, say, a couple was married for, say, a month or 2 months and they've separated immediately, can they then speed up the divorce instead of waiting for that 6-7 month period? Or is it that no, somebody was married for a while, then they've been separated for a while? How does this work exactly? Are there any set guidelines, or is this a case-by-case basis the court can decide what is happening?
It is definitely a case-by-case exercise. There are no set guidelines. You said, for example, okay, 1 month. But it could be something which is so dramatic that has happened in that 1 month that it would give you enough reason to believe that the marriage is broken down. So you can't even rule that out completely. There are many situations where a breakdown can happen within a month, especially in a country where marriages take place not by mutual consent,
but by family
consent.
Just one last question, ma'am. Will these couples then have to come to the Supreme Court to get relief, or can the family courts also grant relief by dispensing with that 6-month waiting period?
Now you've mixed up two questions. One is dispensing the 6-month period, which is under mutual consent. Yes, the family courts can dispense with that 6 months waiting period. But your second question, which was mixed up in one question, was about irretrievable breakdown of marriage. Family courts ordinarily cannot give a divorce on the ground of breakdown of marriage. What the court has said is we, in exercise of powers under 142, can, if the petition is pending under Article 136, we can do it if we come to the conclusion that this marriage has been irretrievably broken down. Most importantly, please, and this is a question that has to be put on the table, the court has said we will only do it once we make sure that proper provision for alimony, maintenance and custody of the children is made. Otherwise, no question for the rest.
Thank you very much, ma'am. So, effectively what the court has done, that irretrievable breakdown of marriage can be taken as a ground of divorce by the Supreme Court if the couple has already gone through the procedure that is prescribed and gone through several years of separation or similar problems that will show that the marriage does not exist any longer. This is basically an addition to the existing grounds of divorce under the HMA and has therefore been hailed as a major reform in marriage law in India. In New Delhi, this is Aneesha Mathur for India Today.